Hi everyone, so my name is Shazia Khan and today's unit that we'll be doing is equity and trusts. And the element that we'll be looking at today is to do with learning outcome 1, and it's to do with historical events leading to the development of equity and the nature of equity. So the unit aim is to equip the learner with an in-depth knowledge and understanding of the principles governing the law of equity and trusts, to enable learners to understand and apply equitable rules to facts-based scenarios, but also to identify and resolve issues that potential clients may face in the context of different types of trusts and equitable remedies. So learners will be able to explore equity interrelates with other topics and how equitable principles apply in domestic and commercial contexts. The indicative content for learning outcome 1 is we'll be looking at the key historical events that led to the creation of equity and common law, the significance of the Earl of Oxford's case, and the distinction between common law, equity, and statutory rules, the administrative fusion of equity and common law, and equitable maxims. So the classification of law. So we'll look at what law is. So you have natural law, you'll have positive law, which is political law, national law or municipal law, and international law. From national law, you'll have constitutional and ordinary law, which is common law. Within that, you've got public and private law, administrative, general, statute, ordinance, case law, and common law. In regards to types of law, we have constitutional law, which is based on the constitution, so any sort of government policy, things like that. Statutory law enacted by legislative bodies. Administrative law are rules and regulations made by administrative agencies. Civil law addresses wrongs done to individuals. Criminal law addresses wrongs done to society. So any sort of criminal offences that commit is a wrong to society. Procedural law deal with the methods of enforcing legal rights and duties, and substantive law defines legal rights and duties, and business law, any sort of transactions that affects businesses in regards to that. Key terminology. So what is equity in the context of law? So equity really essentially means to do with fairness. So our legal system in the UK is based on areas of law that gave birth to the law of trusts. And trust is a set of rules that have been established to regulate situations where one person places trust in another person to look after their affairs. So the legal definition of trust is of equity is in the Oxford Dictionary, describes it as a branch of law that developed alongside common law and is concerned with fairness and justice, formally administered in special courts. In law, the term equity refers to a particular set of remedies and associated procedures involved with civil law. These equitable doctrines and procedures are distinguished from legal ones. A court will typically award equitable remedies when a remedy is insufficient or inadequate. Equity, like we said, essentially means fairness. Equity stretches across all areas, so it's an incredibly important part of the legal system. But the majority of people working in this area of law dealing with the various intricacies of trust law. So, you know, equity law is an example of it. If someone is infringing a trademark of yours, you can get monetary damages for that in regards to, you know, identifying that, you know, there are issues around that. Equity, also known as the law of equity, is used and developed in England, and it provides remedies and solutions that you may not always get through common law, and is designed to address situations where strict application of legal rules may lead to unjust outcomes. Equity has its roots in medieval legal system of England, so it goes back quite a long time. So what is the principle of equity? So equity proceeds in the principle that a right or liability should, as far as possible, be equalized among all interested. So in other words, two parties have equal right in any property. So if it's distributed equally as per concerned law. Key historical events that led to the creation of equity. So equity came into existence in the 13th century. As we said, equity has its roots in medieval legal system in England. In the early days, common law was the primary legal system, but it had limitation in addressing certain types of disputes or providing appropriate remedies. People sought redress from the king, who would delegate these cases to the Lord Chancellor. The Lord Chancellor, in his capacity as the representative of the king, dispensed justice based on fairness and conscience rather than the rigid legal rules. One of the defining features of equity is the availability of unique remedies, not typically provided by common law. Some common equitable remedies include things like specific performance, where the court can order to fulfill his contractual obligations when monetary damages are insufficient, injunctions and rescissions. And, to identify that the whole point of equity focuses on principles of fairness and justice, providing any sort of remedies or solutions through common law. What common law means in brief. Common law, as we mentioned, is a system of principle of based on principle of common law is based on the principle of precedent and case law. So previous precedent and common cases that would identify that. So common law system can trace back to roots or in many years, many centuries. Indeed, the common law started in England in the Middle Ages. Several countries around the world, as we mentioned, including the US, Canada, India, and Australia, continue to rely heavily on common law when resolving any sort of disputes. The simplest definition of common law is that it is a body of law based on court decisions rather than codes or statutes. But in reality, common law is often complicated than that. At the centre of common law is a legal principle, which is a really important legal principle, known as stare decisis, which is the Latin phrase that roughly means to stand by things decided. In practice, stare decisis is just a fancy way of saying that courts and judges need to follow any sort of earlier decisions and rulings, otherwise known as case law, when dealing with similar cases later. For example, if a court makes a particular decision based on common specific set of facts, then the court is required to follow that decision if they must make a ruling on the same or closely related issue. Likewise, decisions made by higher courts, like a jurisdiction's Supreme Court, are typically binding on lower courts in the same jurisdiction. As we mentioned, there are many countries throughout the world that use common law systems, including the United States, which originally based its common law rules on English law. In fact, every US state, with the exception, as we mentioned, of Louisiana, has a common law legal system. And it's being used. It's being used in America for centuries. Common law states have countless codified statutes that courts must take into consideration. So, common law is used throughout the countries in regards to trying to refer back to case law and previous precedent. The importance of law of trust. So the law of trusts has often been referred to as one of the most important and enduring creations of the Court of Chancery, the court responsible for the administration of body of law. Equity was originally developed as a response to the harsh outcomes resulting from the rigid application of common law rules. In contrast to the strict rules of common law, equity is categorized by its concern with individual justice, morality, fairness. English law concerns the creation of protection of asset funds, which are usually held by one party for another party's benefit. Trust were a creation of English law of property and obligations, but also share history with countries across the Commonwealth and the United States. Trust developed when the claimants in property disputes were dissatisfied with the common law courts and petitioned the king for a just and equitable result. Historically, trusts were most commonly used where people left money in a will, created family settlements, created charities, or some types of business ventures. English trust law. So after the Judicature Act 1873, England's courts of equity and common law were merged and the equitable principles took precedence. Today, trust plays an important role in financial investments, especially in unit trusts and pension trusts, where the trustees and fund managers usually invest assets for people who wish to save for retirement. Although people are generally free to write trusts in any way they like, an increasing number of statutes are designed to protect beneficiaries or regulate the trust relationship, including the Trust Act 1925, Trustee Investments Act 1961, and the Recognition of Trusts Act 1987, Financial Services and Markets Act 2000, the Trustee Act 2000, Pensions Act 1995, Pensions Act 2004, and the Charities Act 2011. Trusts are usually created by a settlor who gives assets to one or more trustees who undertake to use the assets for the benefit of beneficiaries. As in the contract law, no formality is required to make a trust except where standard statute demands, for example, transfers of land, shares for wills. To protect the settler, English law demands a reasonable degree of certainty that trust was indeed intended. To be able to enforce the trust terms, the courts also require reasonable certainty about which assets were entrusted and which people were meant to be the trust beneficiaries. 1.1. Explain historical events leading to the development of equity. So to attempt to counteract the discrepancy, remedies could be obtained by petitioning the king, who had residual judicial power to deal with such matters. The king began delegating the function of dealing with such petitions to the chancellor. The post of the chancellor at this time was usually a clergyman and king's confessor. The chancellor involved in a judicial body known as the Court of Chancery until by the end of the 15th century, the judicial power of Chancery was fully recognised. The Court of Chancery was in effect developed as a court of conscience to counteract that defects existed in the common law system. The rules of equity varied from chancellor to chancellor until the end of the 16th century. As equity developed, it began to conflict with common law. Litigants used equity to their advantage, often seeking an equitable injunction, prohibiting the enforcement of common law order. So if a common law judgment was enforced in disobedience of common law injunction, then the person enforcing the judgment could face imprisonment. Historical background before the Norman conquest. So the time period was from the 8th to the 11th century, so over a 400-year period. The place was medieval England. The background was the transformation of England from a number of proto-states, tribal chiefdoms, to a centrally governed country. The economic reasons behind it was that there were former tribal land became owned and controlled by powerful lords. The social reasons, the responsibility of an individual to his kinsman was replaced by the responsibility of a person to his lord. The reasons of justice, it became the prerogative of feudal lords to see that justice was done. The political reasons was to consolidate power. Feudal lords required the dispute submitted to a local court for settlement. The key dates that we need to look at in regards to this was in 1066, the victory at Hastings, following which common law started evolving in medieval England. 1166, the Assize of Clarendon established the grand jury system for investigating recent crimes. 1176, the Assize of Northampton established a jury of presentment to decide which cases should be tried. 1181, Assize of Arms ordered all free men should keep arms and be prepared to defend the country. 1215, the trial by ordered ordeal was cancelled. 1258, the provisions of Oxford forbade the issue of new writs, so thus common law became too rigid. 1474, the Chancellor issued the first decree in his own name, which began the independence of the Court of Chancery from the King's Council. 1616, the Earl of Oxford's case gave rise to rivalry between common law and Court of Chancery. Court of Equity was decided that in the cases of conflict between common law and equity was to prevail. In 1854, the common law procedure gave common law power to award equitable remedies. 1858, the Chancery Amendment Act gave the Chancellor the power to grant damages in addition or in substitution for an injunction or a decree of specific performance. In 1873 to 75, the Judicature Acts caused the fusion of common law and equity courts into the Supreme Court of Judicature. So this is a timeline of the key dates in regards to equity and common law. The significance of the Earl of Oxford's case. So I'll just give you a little bit in regards to a bit of the background of the Earl of Oxford's case. This case occupies a rather unique position in the development of English legal system, and it's frequently referred to as the cornerstone of equity in modern English legal system. It could be said that the case shares an ipso facto relationship with the Court of Chancery, with each party relying unconsciously on the other existence for their development. Ipso facto is a phrase believed to have been made popular by Thomas Gray, poet and historian in the 18th century, with its origins to be found in Old English and Latin. So in the Earl of Oxford's case, the Court of Chancery, as we said, issued a common injunction prohibiting the enforcement of a common law order. The matter was referred to the Attorney General, Sir Francis Bacon, when no resolution could be reached between the two courts. Sir Francis upheld the common injunction and stated that in the event of any conflict between common law and the law of equity, equity would prevail. Lord Ellesmere pointed out in the case why there was a need for a chancery. He stated that men's actions are so diverse and infinite that it is impossible to make any general law which may aptly meet with every particular and not fail in some circumstances. The office of Chancellor is to correct men's consciences for frauds, breaches of trust, wrongs and oppression of what nature is soever they be, and to soften and mollify the extremity of law. So by the 17th century, only lawyers were appointed by the office of Chancellor. From 1529 onwards, when Sir Thomas More was appointed as Chancellor, records of proceedings in courts of chancery were kept, which led to the development of equitable doctrines. Prior to this appointment, no such records were kept, and the decisions made by the chancellors were discretionary and erratic. By the beginning of the 19th century, the Court of Chancery had become a court of equity. This case, actually, the Earl of Oxford case, demonstrated how fragile and sustainable equity was to political upheaval during the 17th century. Equity was dependent for its authority upon the king's prerogative during this time. It was significantly jeopardized by the events such as the overthrow of Charles I. So it actually identified how the law of equity was quite quite fragile in regards to political opinions. So the next element of this is the case of G and Pritchard, which I'll give you a little bit of background to the case so you have a knowledge of what happened in the case. So in this case, the facts was that William G had been the Lord of Beddington Park in Surrey. William Pritchard was his son, and Mrs. Anne Paxton G was Pritchard's mother. Pritchard was a rector at Walton on the Hill close to Beddington Park. Pritchard was the son of the late Lord, born of an extramarital affair. However, Mrs. G had been on good terms with her stepson for many years. She wrote him letters about what she thought of his life and gave him moral guidance, and also received letters from him. Time came when they ceased to be on good terms, and Pritchard threatened to publish the letters. At this time, Pritchard sent the original letters back to Mrs. G with a letter saying that he was returning the correspondence, but he had secretly made a copy of the originals. However, in a letter dated 14th of May 1818, Mrs. G was notified that Pritchard intended to publish the letters. His claim was that he sought to publish not for monetary reasons, but for the various actions brought him into disrepute with the parishes, and he needed to clear his name. Pritchard claimed that the letters were his private property and he was entitled to make such use of them as he might deem proper. In a bill, Mrs. G sought an injunction restraining the publication of letters or any copy of the original letters. She felt that the action was a breach of private confidence and it would wound her feelings and could have no other effect. The court held that in this case, it was involving injury of property and rejected the idea that publication would hurt the plaintiff's feelings. Lord Eldon held the plaintiff had sufficient property in the original letters to authorize an injunction. Lord Eldon stated that the question would be whether the bill has stated facts which the court could take notice as a case of civil property, which is bound to protect, and as in equity, a party is not entitled to a writ, an injunction for a matter affecting his person. In conclusion, the court granted Mrs. G a temporary injunction on grounds of protection of the property. The primacy of equity, as stated by Sir Francis, was later enshrined in the Judicature Act 1975, Section 25, which also joined the Courts of Equity and the Courts of Common Law into one under the title of the Supreme Court. The Supreme Court was divided into two, forming the High Court and the Court of Appeal. The High Court was further divided until 5 different headings gave rise to the Chancery Division, the King's Bench Division, Common Pleas Division, Exchequer Division, and the Probate, Divorce and Admiralty Division. The central feature of the reform was that every court would now possess the power and have the duty to decide cases in line with common law and equity. Where there's discrepancy between the common law solution and an equitable one, the precedence of the Earl of Oxford case still applies, meaning that equity could be paramount in the decision-making process. The Supreme Court 1981 Section 49 was embodied this principle and instructed that, number 1, every court exercising jurisdiction in England and Wales in a civil cause or matter shall continue to administer equity law, and on the basis that wherever there is a conflict or variance between the rules of equity and the rules of common law with reference to the same matter, the rules of equity shall prevail. Before the common law courts, the Court of Chancery became one. Common law actions could only be commenced by means of a writ, whereas actions in the Court of Chancery were commenced by an informal bill of complaint, and the process began by the use of subpoena. Chancery hearings were informal and were not restricted to being able to sit at certain times, as the case with common law courts. The administrative fusion of equity and common law, the Judicature Acts. So Ashburner's view of this was the two streams of jurisprudence they run in the same channel, run side by side and do not mingle do not mingle their waters. Although equity and common law are fused together in that a court is entitled toward equitable remedies or common law remedies or a combination of both with the same court, there are some areas of law where the distinction between legal ownership and equitable ownership still thrive. One such area is the formation and management of trusts. Before the introduction of equity into the legal system, persons wishing to dispose of their property by way of a trust were faced with the difficulty of passing ownership to their intended beneficiaries without giving them the property outright. Under common law system, the transfer of property into hands of the trustees could be read as giving full title to the trustees. No account would be given to the concerns of the beneficiaries. The Judicature Act 1873 and 1875 are a series of acts of Parliament beginning in the 1870 which aim to fuse Heathon split system of courts of England and Wales. The first two acts were the Supreme Court of Judicature 1873 and the Supreme Court of Judicature Act 1875. Besides this restructuring, the objects of the Act were threefold. Firstly, to combine the historically separate courts of common law and equity. Secondly, to establish all the divisions of the new Supreme Court, a uniform system of pleading and procedure. And thirdly, to provide for the enforcement of the same rule of law in areas where equity and common law recognize different rules. 1.2, examine the relationship between law and equity. In modern practice, perhaps the most common distinction between law and equity is a set of remedies each offers. The most common civil remedy a court of law can award is monetary damages. Equity, however, enters injunctions or decrees directing someone either to act or to forbear them from acting. There are 5 stages of equity. Firstly, the introduction of common law. Theory on binding precedents and resulting case law equity. Secondly, as a legitimate consequence, the crystallization of equity culminating from under Lord Eldon. Thirdly, the adoption of equitable actions and equitable defences in common law. Fourthly, the conjunction of legal and equitable jurisdiction in the same courts. And fifthly, the abolition of distinction between law and equity in procedure and the resulting power of courts to administer both in either the same. So common law equity, as we mentioned, are systems developed in English court. Common law is a system based on judicial decisions and precedents rather than on statutes and codes. Equity is a system that developed to address the limitations of common law, and it's based on principles of fairness and justice and seeks to provide remedies where the strict application of common law would lead to unjust results. Over time, common law and equity systems became increasingly intertwined with common law judges beginning to apply equitable principles in their decision, as we mentioned earlier. And, you know, many legal systems around the world incorporate both common law and equitable principles. Even though the systems have some differences, they still share the commitment to fairness, justice, and the protection of individual rights. So still nowadays, everyone does use, you know, there's a link between common law and equity, and they both use, the elements are used by both. So the meanings of equity is body of rules administered by court of equity. It's to do with fairness. It's to share or participatory interest in a limited liability company, a value of property over and above encumbrances, and it's an equitable right to claim. So it's equity of redemption. The relationship between common law and equity. Common law was originally based, as we mentioned, on customs and traditions that governed England, and the royal courts were in charge of ensuring proper administration of these laws. The law of equity, as we mentioned, is a set of rules created by the courts of chancery in order to mitigate the harshness that common law system provided to the country. The courts of chancery introduced the law of equity in order to fill in the gaps of common law that common law failed. Common law system provided to the country to fill in the gaps that common law failed to address. In addition, equity sought to avail kind of flexibility in the law because of the common law presented a rigid system. Equity is fair and just rule and looked at, you know, it's all to do with fairness. So in contrast, equity originated to mitigate the rigidities of common law and provide more flexibility when common law was unable to give remedy or injustice. Equity developed, as we mentioned, from the English Court of Chancery, which was headed by the Lord Chancellor. He had the power to overrule common law decisions if they failed to provide a fair or just result. Equity deals with many trusts, mortgages, administrator of estates, charities, contracts, monetary damages, and inadequate. Today, most jurisdictions have fused the administration of common law and equity, as I mentioned earlier. However, they continue to play distinct roles. Common law focuses, as you mentioned, on legal rights and obligations, while equity aims to provide a more flexibility and fairness. Equity will always prevail over common law when there's a direct conflict between the two bodies. However, if a matter falls within the common law doctrine of precedent, equity here will rarely interfere with common law ruling. The biggest distinction between law and equity cases related to type of remedy or relief sought by the plaintiffs. So differences in remedies. So the common law availed only monetary remedies when addressing grievances brought forward by the parties of a case in order to determine which party can claim victory of a case. This limited the ability of the courts of law to address other issues that fell outside the scope of monetary compensation. The law of equity brought about a system where judges would weigh the particulars of the case to determine whether to avail a remedy in terms of damages or to provide a remedy that did not border on financial grounds, such as injunction, thus boosting the remedies available to the parties. The development of so legal cases typically seek monetary damages, as we mentioned, as a remedy. For example, a plaintiff may sue for breach of contract and ask the court to award them money to compensate for their losses. In contrast, equitable cases seek non-monetary remedies such as injunctions or specific performance. For example, a plaintiff may ask the court to order the defendant to do or refrain from doing a particular act. Some key differences between law and equity. So remedies, legal remedies are monetary, the procedure and discretion and fusion. So development of precedent. The judges in common law system declared the substance of law when they made decisions regarding the different types of cases. The judges in chancery courts were administered the rules of equity brought about the justice, the system of judge-made law, which is based on precedents. The judges look into previous judgments made in order to direct the presentation of justice in another case with similar facts. The system of judge-made law developed over the years, even after the merger of the common law and equity to form common law that stands today. So basic distinction between common law and equity. Decisions in common law are made by reference to precedent, stare decisis, which I mentioned earlier, and the only remedy is damages, which is money, and it operates in a rem. It establishes general rules which provide certainty. In equity, the emphasis is laid down on fairness and flexibility and the maxims of equity. Remedies are as orders to do so, not to do something, specific performance, injunction, rescission, rectification, and it operates in persona and it acts as a check and balance of common law. So 1.3, explain the meaning of equitable maxims. So there are different equitable maxims that need to be referred to in regards to equity. So with the evolution of equity as a body of law, a set of structured maxims that assist in the interpretation of discretionary jurisdiction were emerged. So there are certain maxims that were emerged that will go through in regards to what these maxims are and what is the importance of these maxims in regards to identifying the elements of equity. So these maxims, they represent the accumulated insight and wisdom of early courts of equity and were often used as guide in the application of equitable principles. So the first one is equity. Equity sees that as done what ought to be done. Second one, equity will not suffer a wrong to be done without a remedy. Third one, equality is equity. Fourth, one who seeks equity must do equity. And fifth one, he who comes to equity must come with clean hands. And sixth, equity follows the law. So the first one we'll be looking at is equity sees that as done what ought to be done. So here, equity will attempt, where fair and possible, to enforce all transactions were agreed upon. For example, equity may enforce an agreement pursuant to an order for specific performance. Equity ensures that any transaction or arrangement which has been fairly and honestly agreed upon is also properly performed. The true meaning of this maxim is that equity will treat the subject matter as to the collateral consequences and incidents in the same manner as if the final acts contemplated by the parties have been executed exactly as they ought to be, not as the parties might have executed it. Here the judges look at this contract from the enforceable side and the situation they would be in had the contract been completed. The second one is equity will not suffer a wrong to be done without a remedy. This maxim is developed as common law with no remedies, only monetary damages. Maxim can be used by the beneficiary of trust whose rights were not recognised by the common law. Equitable remedies such as injunctions or specific performance may be given. So courts will commonly apply common law, and it's not fair that an equitable remedy will be provided. The maxim sets out that equity is not in place to overrule judgments in common law, but to make sure rather parties don't suffer an injustice. Equality is equity. So equality is equity is where more than one person is involved in owning a property. The courts prefer to divide property equally, prior to treat all involved as equals. In the case of a business, any funds left over from dissolution should be divided. So this is trying to treat everyone as equal as possible. This maxim is particularly relevant in cases involving more than two parties, where a pro rata distribution is generally presumed. This should be only applied when it is not otherwise possible to determine the respective shares or equities. The next one is one who seeks equity must do equity. One who seeks equity must do equity. A remedy will only be provided where they have acted equitable in the transaction. This maxim is discretionary in nature and is concerned with the future conduct of the plaintiff. And a popular case in regards to this is the case of Cheese and Thomas, 1994. He who comes to equity must come with clean hands. The doctrine of unclean hands is an equitable defence to an equitable claim. Secondly, where it applies, the party suing may still assert such rights as are available to law. Thirdly, the defence is distinct from the defence of illegality. So where the defence is available, it is not necessarily to rely on equitable principle. And fourthly, the conduct relied on must relate directly to the equity relief on. Finally, a party who offends the principle may wash his or her hands of the impropriety. The impropriety of uncleanness necessary to generate the maxim is generally constituted by some sort of fraud or improper behaviour on the part of the plaintiff. The maxim functions as to a defence and therefore focuses on the conduct of the plaintiff seeking the assistance of equity rather than the conduct of the defendant. Further, the conduct which is relevant for this maxim is past rather than prospective conduct of the plaintiff. This maxim, linked to the previous maxim, relates to the past conduct of the parties, as we mentioned. A case in regards to he comes to equity comes with clean hand is the case of Overton and Bannister 1844, where a beneficiary failed in their action against the trustees to pay her back the assets of the trust she had already received as a result of misrepresentation of her age. There are also some other ones as well that you could look at in your own time in regards to the maxims. The popular one is equity looks to intent rather than form. So here, equity will look at the substantial fairness and not consider itself bound by a form when considering the circumstances and laws applicable to a particular case. Equity will not regard itself as being bound by formality. Another one that you could look at is equity acts in persona. So this maxim states that equity relates to a person rather than their property. It applies to a property outside a jurisdiction, provided that a defendant is within the jurisdiction. Another one is that where the equities are equal in the first time prevails. So here, where two parties have the right to possess an object, the first one with the interest will prevail. Another one is equity looks to the intent rather than the form, and principles were established in the case of Parkin and Thorold 1852. Sorry, this maxim is where the equitable remedy for rectification was established. This allows for the contract to be corrected when the terms are not clearly recorded. This maxim allows the judge to interpret the intentions of the parties if the terms aren't recorded properly. So these maxims are really, really important when you take into considerations, you know, there are general principles adopted that need to be followed, and judges will rely on them. You know, that they rely on them because they take into account that these maxims have been, you know, implemented to follow, and there are guidelines that need to be followed. So some equitable remedies, finally, just to have a look at. The first one is injunctions, and this is an order to court to make an action or to make or refrain from doing an action. You've got other ones like interlocutory injunctions, which is granted prior to a court hearing because plaintiff may suffer an unrepairable damage. They've got the other elements, which is Q timing injunction, which prevents an act before it has committed. It may be feared or could have been threatened. So the plaintiff must show that there's a strong possibility of this happening, and the consequences of the act will extremely be damaging. The burden of proof is higher. And then you've got the Mariva injunction, known as the freezing injunction, where one feels that they have substantial case against the other. They can apply to the courts for this if they feel the other may move or hide its assets. Then an ante pillar injunction order, and then specific performance and rescission. So these are the different types of remedies available in regards to the maxims. So, it's important the maxims are used to help, in regards to trying to implement and have any sort of guidelines in regards to it. So they're relevant in these maxims are relevant in the concepts of priorities in relation to legal rights. So they need to be relied on, and the courts will rely on these maxims to make a decision. Key terms in regards to this are A, which is a court held by internal royal justices in medieval England. Assizes, meetings with barons that issued binding decrees. A writ is a document setting out details of the claim. And then you've got equity is a body of rules administered by the Court of Equity. So, and then you've got remedy in the way it is enforced by court of law or equity. So, in regards to common law and equity today, it's perhaps the most important distinction is that is used today in today's society, and it's relevant because it's equity, as we mentioned in conclusion, it stands alongside common law, but it remains a body in its own law. So its own right, it's got its own right, but it still stands alongside common law. The trust is perhaps the most easily recognizable and important development of equity. Today, it is perhaps also the ultimate and blatant example is what is meant by equity interfering with the strictness of common law. So, they are merged together, and they were merged together by the Judicature Act to come up, and to identify why they are so important. Today in today's society, they're both used, but they are used together as well. Lots of, because if you think about it, equity is to do with more fairness. It brought in a lot of different remedies, which common law didn't have at that time. So they work together, and they work well together, and the maxims help them identify the principles, but also, the whole point of equity being brought in was to do with fairness in just any injustices that were being dealt with, tried to implement any sort of injustices. So the references for Learning Outcome 1 that we've used today are the Parliament.uk about living heritage, Wikipedia and BizFluent. These are some of the references that you need to refer to if you want to do read around Learning Outcome 1. Again, if there's any sort of plenary in regards to use some ebooks on Moodle. Also, if you have any questions, refer to learner work at ukvarsity.co.uk. And the submission of the assignment is normally 2 weeks after the unit has been completed, which is the 2 weeks after that. So we've finished now Learning Outcome 1. If you have any questions, please refer to additional reading, any sort of additional resources on Moodle. If you have any questions, please email learnerwork@ukvarsity.co.uk. And if you have any issues in regard to submission of the assignment or any questions or queries, again, refer to learnerwork@ukvarsity.co.uk. Thank you for attending today's session. And the next session we'll be doing on equity and trust is learning outcome 2. Thank you.